A common question I get is, will I lose my earnest money? It's important to understand potential contract contingencies. So be sure to go over the contract with your real estate agent. Two scenarios that may lead to the forfeiture of your earnest money, which by the way is also called good faith deposit, are waiving your contingencies. Financing and inspection contingencies protect your earnest money if your financing fails or the house is beyond repair or anything else written into the contract that is a contingency, protected by your earnest money. However, if you waive these contingencies, you forfeit your good faith deposit if the house does not go to close of escrow. Also, ignoring timelines. Home purchase contracts often have timelines which the buyers should complete during the purchase process. Failure to complete these contingencies within their timeline or close the transaction on the agreed date means you have breached the contract. You may have to forfeit your good faith deposit. So, what if you change your mind? Property buyers get their earnest money back if the deal goes south for reasons covered in any outline contingency in your purchase contract. Possible examples could include denied financing approval, appraisal issues, or an unacceptable inspection report. Otherwise, there's little or no chance of a refund. If you change your mind late in the buying process for reasons other than contingencies, the seller can keep the earnest deposit. It compensates them for the time, money, and effort required to list the property again and obtain another buyer. The following could potentially protect your earnest money from fraud or unjustifiable forfeiture. Put everything in writing. Make sure your contract clearly defines what amounts to canceling the sale and who ends up with the earnest money. Include any amendments to details like buyer responsibilities and timelines. Use an escrow account. To avoid trust issues, never hand your earnest money directly to the real estate seller or broker. Let an escrow company, legal firm, title company handle this. Make sure the funds are in an escrow account and obtain a receipt. Understand the contingencies. Ensure that contingencies that protect your interests are in the contract. Most importantly, beware of a home purchase agreement that doesn't have clauses that protect you. Meet your responsibilities. Real estate purchase agreements usually set deadlines to protect sellers. Be sure to respond to all questions and provide requested documents from your lender, real estate agent, attorney, HOA, or title company in a timely manner, as well as meet inspection, appraisal, and closing deadlines to avoid breaching the contract. Bottom line, be sure to use an escrow account. Understand the contingencies and timelines in your purchase contract and what the written remedies are if you were to breach them. If you've been thinking about buying a home, reach out to me so I can help you navigate through the buying process.